Hello and welcome to a new episode of SCC Online Weekly Rewind. In this episode, I will bring you the top updates from Supreme Court, High Courts, and legislative updates. The top news of this week is that the Supreme Court has upheld the amendments to the provisions of the Foreign Contribution Regulation Act and held that receiving foreign donation cannot be said to be an absolute or even a vested right. Keep watching this episode for this and a lot more. The Supreme Court has upheld the validity of the amendments to the provisions of the Foreign Contribution Regulation Act of 2020 via the Foreign Contribution Regulation Act of 2020. The amendments were challenged for being manifestly arbitrary, unreasonable, and impinging upon the fundamental rights guaranteed to the NGOs under Articles 14, 19, and 21 of the Constitution. The court, however, was of the opinion that receiving foreign donation cannot be said to be an absolute or even a vested right. By its very expression, it is a reflection on the constitutional morality of the nation as a whole, being incapable of looking after its own needs and problems. Asking the question that in normal times why developing or developed countries would need foreign contribution to cater to their own needs and aspirations, the court observed that the aspirations of any country cannot be fulfilled on the hope of foreign donation, but by firm and resolute approach of its own citizens to achieve the goal by sheer dint of their hard work and industry. The court also observed that the foreign aid can create the presence of a foreign contributor and influence the policies of the country, and therefore the presence or inflow of foreign contribution in the country ought to be at the minimum level, if not completely eschewed. In a case where the Supreme Court was posed with the question as to whether the state can, merely on the ground of delay and lashes, evades its legal responsibility towards those from whom private property has been expropriated, answering in negative, the bench held that the state cannot shield itself behind the ground of delay and lashes, as there cannot be a limitation to doing justice. The state of Himachal Pradesh utilized the subject land and adjoining land for the construction of the Narag Phagla Road in 1972-73, but allegedly no land acquisition proceedings were initiated nor compensation given to the appellants or owners of the adjoining land. The court noticed that the state had, in clandestine and arbitrary manner, actively tried to limit dispersal of compensation as required by law only to those which it was specifically prodded to by the courts, rather than to all those who were entitled. Hence, the court not only directed the state to pay the compensation to the said landowners, but also imposed costs on the state. In another case, the Supreme Court has held whether corporate debt of an entity upon amalgamation per se invalidates a tax assessment order or ordinarily cannot be determined on a bare application of Section 481 of the Companies Act of 1956 and its equivalent in the 2013 Act, but would depend on the terms of the amalgamation and the facts of each case. In the case at hand, Mahagun Realties Private Limited, a real estate company, amalgamated with Mahagun India Private Limited, but the assessment order showed the assessee as Mahagun Realtors Private Limited, represented by Mahagun India Private Limited. Finding no fault with the assessment order, the court observed that despite amalgamation, the business enterprise and the undertaking of the transferee or the amalgamated company, which ceases to exist after amalgamation, is treated as a continuing one, and any benefits by way of carry forward of losses of the transferor company, depreciation, etc. are allowed to the transferee. Therefore, unlike a winding up, there is no end to the enterprise with the entity. The enterprise in the case of amalgamation continues. Expressing that legal profession is a noble profession and is the lawyer who plays a predominant role in securing every citizen's life and personal liberty, fundamental and statutory rights ensured by the Constitution, Madras High Court has observed that law officers perform their duties without profit motive and with a service mentality for a nominal fee as compared to those with their lucrative private practice. Bench also remarked that once you accept that to defend the government or its agencies, you cannot complain of the poor and nominal fee paid by them, for the government is for the people and is not destined to make profit but to serve the people. With regard to the legal profession being a noble profession, the court expressed that when a lawyer for an individual client fights for the life and liberty of his client, the law officers of the state are tasked with onerous responsibilities to strike a balance of individual and fellow citizens' rights along with the state, its policies, welfare schemes, etc. Expressing that family court has been functioning in a like manner of an ordinary civil court, the division bench of the Kerala High Court has remarked that family courts have to be impartial or neutral. Kerala High Court noted that the side plight of the functioning of the family court often is portrayed before the High Court by challenging the orders invoking Article 227 of the Constitution. Further, the court stated that the purpose of restricting the challenge to the final order has been lost as the family court is more engrossed in passing interim orders focusing on the rights, obligations, on disputes rather than focusing on the parties before them. The High Court, while answering the question, do family courts have to remain a neutral umpire to the real dispute between the parties, in negative, and elaborated that no doubt judges of family courts have to be impartial or neutral, but the proceedings or process are not ordained to be away or aloof from making inquiry to find the real truth behind the dispute. Expressing that to care for those who once cared for us is one of the biggest honors, Kerala High Court, in a manner wherein a senior citizen approached the court with her grievance with respect to her son, observed that when the senior citizen or parent who has earnings makes an application to the maintenance tribunal contending that her right to earning is obstructed by the son who has statutory obligation to maintain the parent, the maintenance tribunal has to ensure that the senior citizen or parent is able to maintain herself from her earnings. Bharati Dangre judge held that provisions of the maintenance or permanent alimony being a beneficial provision for the indigent spouse, Section 25 can be invoked by either of the spouse where a decree of any kind governed by Sections 9 to 13 has been passed and marriage tie is broken, disrupted or adversely affected by such decree of the court. On April 4, 2022, the central government has notified the Drugs Fourth Amendment Rules of 2022 to further amend the Drug Rules of 1945. The amendment modifies the time period for the application of renewal of license and provides that it must be made within 18 months of expiry. The central government has notified the company's Management and Administration Amendment Rules of 2022 to amend the company's Management and Administration Rules of 2014. The amendment inserts a proviso in Rule 14 which deals with the inspection of registers and returns. The proviso states a list of particulars of the register or index or return in respect of the members of a company shall not be made available for any inspection. On April 5, 2022, the Central Board of Direct Taxes has issued the e-Dispute Resolution Scheme by the Dispute Resolution Committee on the applications made for the dispute resolution under Chapter 19AA of the Act in respect of the dispute arising from any variation in the specified order by such persons or class of persons as may be specified by the Board. On 5th April 2022, the Ministry of Finance has notified the Income Tax 7 Amendment Rules of 2022. The Central Board of Direct Taxes with the new financial year aims to bring more transparency in the tax payments and returns by reducing the disputes between officials and authorities and the taxpayers. These rules will be made applicable with immediate effect. The Central Board of Direct Taxes has also notified the amendment to the Income Tax Rules of 1961 through the Income Tax 6 Amendment Rules of 2022. This amendment aims to tax incomes from the retirement benefit account from 1st April 2020. On 30th March, the central government passed the Finance Act of 2022 for the financial year 22-23. This act will be effective from 1st April. The government adopted various changes in the direct and indirect taxes through this and also introduced the virtual digital asset as a taxable asset under the Income Tax Act. This act modifies the Income Tax Act to provide a relief to disabled persons by paying annuity or lump sum for the benefit of a dependent. The question for this week's SCC online quiz was: which topic covers child rights law under curated topics of SCC online web edition? Answer to this question is public law. The winners of this quiz are Prashant Bhushan and Akash Kumar Baklekar. Thank you for watching. Stay tuned next week for more updates.